Hello, hello, friends. Welcome to Investment Immigrations. I'm your host, as ever, Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. And this is the episode that I know everyone looks forward to all year. And this is our year-end webcast where we look back at everything EB-5. And this year is ever so special because, first of all, look at this lineup. And this isn't even the whole cast. We're missing Aaron Grau. And this is year one of the EB-5 Reform and Integrity Act. And I don't know about you all, but I've got my coffee. I was up till 3 in the morning working. So I dare say EB-5 RIA is working, to take a page from IIUSA's rallying cry. So hopefully Aaron will be able to join us. My apologies for starting late. We've had some technical difficulties. And we all wear a couple of different hats. So I usually don't do this. You know, we like to keep it super informal, but I am going to go around and kind of just ask everybody to just say who you are. And then I will glow afterwards. So Bill, you go first.
Sure. Thank you so much, Carolyn. Thank you for inviting me to this year-end review. I still can't believe it's the year-end. It's like things are happening too quickly. So I am the president of IIUSA, and I'm very proud of the work that IIUSA has done, not only in the last year, but for years and years. And I am also the president and founder of EB-5 New York State. And we're a regional center that's been in business since 2007 and with lots of successful projects and happy investors.
And so close to Ithaca, based in Buffalo.
Stone's throw. A snowball's throw.
A snowball. A nor'easter away. David Morris, you go.
Well, I'm outside of the Western New York bubble that ranges from Buffalo over to Ithaca, but I still feel that the no sun gloom of Western New York. I feel it here in Virginia. And Carolyn, EB-5 works. I don't know. I think like the RIA is making us work, but I don't know if it's working. So that's a little teaser.
Ooh, okay.
Right? So I'm David Morris, AILA lawyer since 1992, working with the EB-5 program since probably 96. And I am the chair of AILA's EB-5 committee, a role that I've had for the last couple of years. I'm delighted to be here. Yes.
Many years. Thank you, Morris. And Ishaan.
Sure. Hey, everyone. My name is Ishaan. First and foremost, I am an EB-5 investor, a product of this very program that we're going to discuss today. I've been working in the EB-5 industry now for the last 7 years, worked for investment issuers raising EB-5 capital all over the world. I currently work for a firm called EB-5 Capital, which has a number of projects all over the country, especially here in the Washington, D.C. area where I'm based out of. I'm also one of the founders of this nonprofit called the American Immigrant Investor Alliance. We are a 501c4 that advocates for EB-5 investors first and foremost. And we advocate for, of course, better use of the program as well. And, I believe it is working. So that's my little teaser, and let's go from there.
Awesome. All right, so Morris, we got to kick it off with you, and maybe you can kind of walk us through what I've been kind of, tongue-in-cheek been calling 2G or not 2G, the form 956G, whether certain regional centers ought to file it. And I have a feeling that topic kind of is related to your perspective on the RIA. So I don't know whether you can kind of like tie it all together, but why do you question whether the RIA is actually working?
Okay, well, I think that's two separate issues. Is it working? Okay. Or I think the one about the G or not to G, I frame that as a question of the RA comes around, and we have had, since this program was a pilot program in 1991, clearer rules on how to create a regional center, maybe some less rules, but some obligations on how to operate a regional center. But we've never had any rules about how to close down a regional center or to responsibly close down a regional center. I think if you were an engineer or you're a businessman or, pick the profession, if you said, I have this great idea and here's how you start it and here's how you run it, everyone's going to say, well, how do you close it down? If you want to start a business, the first question you ask is, what is it? And then the second question is, how do you get out of it?
Yeah.
And
Without being
so-
forced to, like without being
Yeah, well,
terminated.
how to get out of it without filing for bankruptcy? How about that? Or how to get out of it without, walking away and being able to hold your head up high. So
Mhm.
the IPO has never addressed this issue, despite the broken record of me and Ayla and many others saying we need clarification on how to get out of this thing. How does a regional center stop working? Vermont probably had the best example of this when they were in trouble. And they said, how about this, USCIS? How about we don't raise any more funds, no new projects, let us responsibly wind down so all the investors who have not yet received conditional LPR status can work their way through and get their green cards, to which the
Yeah.
service said no, and the AAO said no, right? And they said for lots of different reasons, including of which one of them is you must always be promoting economic development, which is the main plank of the regional center program. So again, we're all left with how do you close? So despite our AILA letters on November 2022 and then October 2023, the service finally came out with some guidance a couple months ago that talked about this new concept of administrative noncompliance, which was the very first time we've ever heard this term. They didn't define it. And it says, more or less, if a pre-RIA regional center wants to wind down, and I think this ties back to the G question, the G or not the G, right?
It
So-
does.
Yeah.
So
for sure.
if a pre-RIA regional center wants to wind down, they can elect to not pay the annual integrity fee. If they're otherwise in good standing, we, the service, will deem that to be administrative noncompliance. We will terminate your regional center. And then all the investors who you had sponsored will be allowed to proceed through with their 526s, conditional LPR, Visa issuance, conditional LPRs, and the filing of the IA-29. And okay, so that's nice. That's kind of a little window of, well, there's some path here, but of course we're lawyers and the devil's in the details. And we say, okay, well, can we write a letter to get this formally done? Will you give us a notice that says you've been, administratively wound down? Will the USAS website on regional centers recognize us as responsibly wound down? No answers to this. So we get to the G or not G. That's your question, I think. And that is, well, if the service made clear that not paying the fee, the annual fee, integrity fee, is an instance of administrative noncompliance that will terminate a regional center and not have consequences. However, simultaneously with the deadline of paying the annual fee is the I-956G annual filing, annual report, which they have not said is an administrative noncompliance if you don't do it. So the big question is, what happens if we, don't pay the integrity fee and don't file G? Will we be shut down for administrative noncompliance before we are shut down for a substantive violation of the 956G?
Yeah, and we don't.
And the 956G is ridiculous because it only applies to, RIA regional centers. If you look at the form itself and the comments that Ayla and others submitted during the notice and comment period of that form. So, I think that's a huge issue. We're all worried about it.
Yeah, I mean, I just to kind of bring that home, I think the open issue there is whether if you are administratively terminated, whether the NCEs have to reaffiliate. I think
Right.
I think a lot of regional centers, responsible, great regional centers, who very much care about investors are, you know, they would be open to being administratively terminated, but we don't know whether their NCEs would be left out there, you know, or whether they'd have to seek reaffiliation, and what's the cost of that, what's the process, and that whole thing. Yeah, Bill, you were going to say something about this.
Well, I actually, I think David and you both have really important points. And I ask myself, not to G or not to G, but why not G? I don't see, I mean, I think that the risk of not filing a G is simply too high. And I think that there are too many unknowns. The cost to file a G is, I mean, it's not nothing, but it's not material, right?
But you know, if you've got like a gajillion, you know, like lots of NCEs.
I understand.
Yeah.
But it's not, but again, it's not, if you've got lots of NCEs, you know, then
a lot of attachment ones.
Yeah, I mean, listen, you got to do the work, right? And so it is work. And then once you've done it the first year, especially for older ones, there really isn't probably all that much that's going to have to be done in subsequent years. I just think that right now there are too many unknowns. We know what's unknown from what David said. There are unknowns that we don't even know about yet. And our concern is the risk factor. And I think that it is the risk to investors that if you don't file a G, what does that mean for administrative noncompliance? And if you don't file the integrity fees, what does that mean? And so that's the issue for us. It's not to file or not to file, but why wouldn't you file? I just don't have, there's no compelling argument in my mind not to do it.
So Bill, you sounded like Donald Rumsfeld there. You know, there's things that we know, there's things that we don't know, and there's things that we know that we don't know, right?
And not knowing the things we don't know.
Ishaan wasn't even born when Rumsfeld was around. So Ishaan,
wait, Carolyn, I have one comment that I want to make back to Bill. So the USAS, I think, or IPO has said, I think really clearly that all pre-RIA regional centers are obligated to comply with the RIA requirements. And so when if and when we file the G form, we are making also attestations in that form about compliance. And so it's, you know, talks about how has this NCE, you know, engaged with a qualified third party escrow agent? How have they complied with all this stuff? And I worry, you know, you think about which fight do you want to have? Do you want to say, I'll file a G and I'll write NA into everything and say, I'm a pre-RIA regional center. We do not comply with the RIA. We want to shut down responsibly. We didn't pay our annual fee. If we file that, then we're making a confession, I would argue, that we do not comply with this. And wouldn't that be grounds for denial or based upon substantive issues versus not filing and saying, you know, I was terminated first under the integrity fee non-payment for administrative non-compliance. Like, I don't know which I would rather be in front of a judge to do. I think maybe not file is, I think, the way I'm leaning toward it.
So
sorry, I just want to interrupt and give the investor's perspective here. I would sort of agree with David too, that it's better to not file in that case, mainly because it stems from what does this mean for the future? I mean, because if you're saying that, oh, everyone should file regardless, right? Even if you're no longer in the EB-5 business, you should file a 956G. So as an investor, as a prospective investor, if I was sitting down today, when I was looking at different regional centers, if I come across maybe a smaller player who's trying to do maybe one regional center project, I may not want to invest with them because, oh my God, what if they leave the EB-5 world tomorrow and don't file the annual statements? I think it's really important that we be fair to everyone as an industry and allow players that no longer want to stay in the EB-5 field a fair exit and make sure that those investors are taken care of. So look, it is a time-sensitive issue up till the end of the year. So let's see how the agency responds to that.
But how do you take care of investors if you don't file?
That was going to be my question.
I think, in my opinion, the easiest answer is the fact that do not have them, have them reaffiliate with the new regional center. Simply take a look at, were the funds invested correctly? Was job creation done? Was the methodology correct? If all of that checks out, great. Why does there need to be a need for it to, still be associated, affiliated with a brand new regional center?
Well, to me as an advocate, and this is like we need answers. We've got smart people here. We've got people who have been doing this for many years, and we're scratching our heads. And this is super important. So, and to that point, I mean, it's not for lack of asking, right, Morris? And we've asked and written letters, and it seems to be sort of like almost a study in like, okay, we're deliberately not going to kind of touch this. And that could be a complete misread. Yeah, I mean, this is like a failure of communication, really.
Well, and
So I feel like, yeah, sorry, Bill, go ahead.
No, and on that point is both to David and Ayla and to Carolyn for your thanks and help with IIUSA's letter regarding whether or not the G should be filed. Carolyn, and I know you too, David, have met with the ombudsman, and everybody has requested this information. Please let us know. What do we need to do? We all want to comply. Just tell us what we need to do to comply. And sadly, we haven't gotten that answer. So,
yeah. So I agree with you guys. It's not for lack of asking, right? So Ayla, we sent out a letter on October 27th of this past year. It was a 3-page letter on exactly this point, right? You have to clarify the urgency of it. We need predictability. The end of the fiscal year is approaching, right? A month passed, nothing happened. And then we and IIUSA and others joined together, and we issued another letter, very similar letter. Time is running out, and in the meantime, we had a stakeholder call with ombudsman and IPO, and I can tell you that I submitted that exact question during the questions and answers 3 or 4 times, and I know the other Ayla members did the same thing. And they just elected not to take the call. Not to take the question, to avoid the issue. So, what's the record? I feel the record is very clear that we have this long ramp of us saying we have to know this time is short. And I think that this is one where the stakes are so high, given the consequences of the investors. This is one where when we go to litigation, and that's where this is going to go, I can't see any type of reasonable judge, not coming down on our side and saying, Service, you're out of your mind to not have clarified this point. And I think if we thought Bering was going to be a beat down of the service, I think this one's going to be worse.
Wow. Well, them's fighting words for sure, Morris. Whew. All right, but I want to pivot, because this is year end. We got lots to talk about. That's a big one. Numbers. It is all about the numbers. We don't have enough, so it's about what we got used. Ishaan, this is you, man. So of course, AIIA has gotten some visibility through its FOIA litigation and pulled out some data. Ishaan, a lot of us have read it. We've digested it as best we can. Many of us have not. Could you just kind of give us the Reader's Digest version of it, and then we'll go from there?
Sure. It's tough to do that because honestly, it's a topic that I myself find really, really confusing. We did a webinar with Charlie and Suzanne and Joey and someone from the Galati law firm, and it's really good. It kind of explains the issue, but it's like an hour and a half long. So sorry about that. But essentially, we know what the supply of visas look like. Now, with the pending I-5260 numbers, we kind of have an idea of what the demand looks like. What we can sort of see from the way the numbers are looking and how the numbers will trend going forward, we do see there being definitely a significant higher demand in the high unemployment category, particularly for countries that are at risk of retrogression. And of course, look, a lot of this is all assumptions. We don't know how many dependents there are per petition. Could it be one dependent like me, or a family of 4 where there's 4 visas taken up? Could many of these petitions even be denied? We don't know what that looks like. So it's hard to kind of estimate.
But we got the nationality. Is that for certain? Is that piece in from the?
Yeah, we have a breakdown of the countries that have invested in the RIA, like the top 4 or 5 that we think have taken up
I-5
the
to-
submitted the
fi-
most number of I-5/260 petitions, broken down by month and by category.
Okay.
So when you kind of look at this data, and we just actually filed another follow-up request for the latest data. Again, now we're trying to go even wider and ask for more countries and ask for more data. But what we're essentially seeing is that there's an invisible backlog that's being created of petitions. And you guys were there on the 2015 days when China backlog and things happened. A lot of it was because the backlog came late because Department of State only released the visa bulletin once many of those petitions had been approved, and then there was a backlog created. Had the agency actually released those numbers and that data back in 2012, 2013, 2014, showing the growing number of Chinese petitions, perhaps the investors would have been better informed and have known that, hey, listen, if I invest today, I might not move to the US for another decade. I may not even get my money back for another 2 decades. Who knows? So it's really critical that the agency does provide us this data on a monthly basis, does tell us, hey, how many I-5/260s were filed? This was the country of birth of the main applicant. This is what we think the number of dependents are per petition. Just some good numbers like that would really help investors not, find themselves in a
Be in
similar
the dark.
situation we were in
Yeah.
2015. Yeah. Let's try and prevent that from happening.
So Ishaan, I haven't looked at the raw data,
Sure.
but you have, and so could you tell whether or not this information, could be released on a monthly basis like that? But I mean, was there anything that to suggest any impediment to the data being released regularly and often?
So I think I'd point you guys to the last USCIS engagement we had on October 20th. And honestly, I found that engagement pretty awesome. I know some of you may disagree with me on that. I think the way they addressed the concerns of pre-RI investors and the sustainment period rules and everything else was done very effectively. There was this part that was brought up about data transparency. In fact, the woman who was speaking, I forget her name, she even said, I'm a data person. I like data. I would like for this data to be out there. However, we are hand counting this data. We're not sure how accurate it is. We don't know how to present it in a manner that is digestible. And, my response to that, and we're going to speak with the ombudsman more about this exact topic, is that, just give us the numbers as you have them. Let us do the analysis. There were issues. So for example, just give you one of the examples, is that when we got the data, there are a few people who have checked both the rural and high unemployment box in the I-5/260. And so if someone's like hand counting it, it's going to come across and be like, oh my God, what do I do? So our response to IP or to USCIS and all is just give us what you have. Even if the numbers aren't accurate to the T, that's fine. At least it'll help us know where the volumes are. It helps us as investment issuers also judge and realize, hey, where is my marketing dollars better spent? Should I be going to, Brazil, where there's only 20, 30 petitions that have come out in the last couple of months? Or should I be going to Colombia, where it's, a lot bigger volume and, a lot more investors coming from there? All that data is important to all of us, investors, industry holders, everyone.
Well, I can't help feeling we're closer. We're a little closer to having that information. Bill, you were about to say something.
Yeah, no, I think that Ishaan is 100% right. We need to get the data. And the fact that CIS can say it's not perfect and therefore we're not going to give it to you doesn't make any sense. Because if it's talk about a Section 107 violation on, the ability to let information, you don't want to give information to single petitioner or whatnot. It's crazy that we don't have this information. It's obvious from what Ishaan has done that the data exists and we need it. And I think that the other thing too is having a subset of data that's 8 months old. It's one of those things, from the old legal term. Well, is it more beneficial than not having it? I think that the number of questions it raises are more than the answers it gives. CIS has the data. Put a footnote that says it's not right. We know it's not right because people check 2 boxes. We know it's not right. And I've seen these things where they've checked high unemployment and it's really rural. People are going to make mistakes. That's okay. That's noise around the edge. We need the data. We need to know how many they're adjudicating. We need to know where they're from. We need to know how many are filed. And only that way will investors and projects be able to say, this is the direction we should go. So it exists. The data exists. The service has got to release it to us.
Especially for projects, it is more critical than anything, because if you're an issuer out there trying to plan for what your next offering would be, and you're aiming to raise 100, $200 million, and let's say your project is in the rural category and most of your investments come from XYZ country, but suddenly if you find out that XYZ country has way too many, investors coming in from the rural category, and they now find out, well, now you won't be able to raise your money. Now maybe your project won't get off the ground. The whole reason why the EB-5 program exists in the first place is to help create jobs in this country. And you're not going to be able to create those jobs if investors, people like me, are not going to want to invest in your deal. And that can only be solved, again, if we have clarity and knowing what the future looks like. So aside from, of course, petition data, that's one side, we also need approval data. How are they prioritizing adjudications? I mean, if you invest in a high unemployment category, are you really looking at a 4-5 year wait, like the USCIS processing time, says on their website? Or is it going to be something a bit more realistic? And same thing goes for the pre-RIA investors too.
Yeah.
So on September 11th, Ayla, we sent a letter out to USCIS, and the subject was request for clarification on the processing times for 526E petitions. Because around that time, or for the kind of weeks before that, we started seeing reports of rural cases being adjudicated in as low as 30 days. I mean, the service can't issue receipt notices in 30 days, and they're getting approval notices in 30 days, while at the same time, if you go to the USCIS website and type in 526, you'll get 5.5 years. So, on this issue of transparency and data and reporting, our letter to them was, so has the service implemented a new policy for priority of rural? Yes or no? Because, issuers are out there in the marketplace claiming our cases are getting approved in 30 to 60 days, right? And if that's true, that's fine. But you can't have a couple approvals and say that is the policy and the rest of them are going to be that way. The service needs to announce we have this, right? I know that the RIA says they are allowed or they should give priority to rural cases, but okay, that's fine, right? That gives them the authority to do it, but a priority can be anywhere from 50% of the current 5-year waiting time to anything else. So if the service is going to do this, they need to let us know so that potential investors can assess reasonably, and we can judge the claims of issuers of how long processing time is going to take. And then at the same time, our letter said, well, if you're adjudicating rural cases in a priority in a couple 6 months, 5 months, how many adjudicators are on these rural cases, and how many have been pulled from the pre-RIA cases? What is the workload assignments?
Well,
And
so I mean, we have a lot of these asks and a lot of complaints. But if I'm looking from the other side, they've done a lot.
What other
right?
side?
Well, if I'm looking at things from the IPO side in terms of what the steps that they've taken to implement the RIA, they just recently published an overhaul of the policy manual. That Q&A online, I mean, we could take issue with the format and can we get a little more notice, and is the web the best way to promulgate important policy? But there's a lot of information that's out there, and I can't help but to feel that they're doing their best. They're doing a lot. There's a lot to do. So how do we, I mean, David, you're expressing some things that you're unhappy about, but what is realistic by way of our expectations, and how do we help the agency prioritize, right? And we all have different, I mean, if you're a rural project, you're going to love the prioritized processing. If you're high unemployment, you're not. If your investors are stuck in the unreserved, you're not. So how, I mean, is there sort of a fair and reasonable way to evaluate the service performance and to help them kind of, focus on what's really, really, really urgent?
So we're in a situation, it's like no one likes policy by RFEs and denials,
Okay.
right? So I don't care that they are giving priority to rural cases. I don't care. But tell us what the policy is, right? Tell us what is the normal processing time of a new rural case. Let us know, because in the absence of them announcing a really simple thing like our target for rural cases is 3 months to 9 months. Fine, we know that. That now excludes these crazy representations that are going out in the marketplace about 30 days. So, Carolyn, they need to explain themselves. Like the questions and answers that they put in, right? They could have published it and then the next day said, we are going to have an engagement on these because we left so many issues undefined to talk about this. They don't
Yeah.
do that. So we
Okay.
can't say they're doing a good job because they're not. They're
Well,
not.
I think and there's another thing that's really important, Carolyn, which is this. There's been such a high focus on rural. The service has approved high unemployment areas as well. So there are 526s that are approved. And again, to David's point, well, that's really interesting, but we used to believe it. I mean, FIFO is so crazy, right? Because we have some cases that are just like crazy that haven't gotten adjudicated while much recent ones have. And so the service needs to let us know. How are they doing current high unemployment? How are they doing current rural? How are they doing current infrastructure, current unreserved? And then how are they doing pre-RIA? I mean, we've got to have clarity. And that, I don't think that's a big ask. I really don't. They've got to have a policy internally and they have the data. They may not, it may not be pretty. I believe firmly that this is a softball.
So
And it's not just, sorry, is what to add to that, it's not just data as well, it's also the adjudication standards too. I mean, there's been RFEs denials on path of funds, source of funds issues, and all they got to do is tell people is that, hey, don't use these money transfer businesses, but it's okay to use these ones. If you are going to use an IVT, here's the documentation you'll need. They can put that forward, and they should, but they haven't. And so, I mean, my suggestion to some of the things that you guys have brought up is FOIA them and sue the heck out of them. I mean, that's what we do. We think it's an effective strategy. It at least gives us some insight into how things work on the inside of the agency, but that may be the only way to get that information out of them.
Well, you know, Ishaan, that kudos to you for taking that approach and being successful. I think that there has been some, you know, the reactions are, well, go from that's fantastic. I mean, thank God we have this data somehow, to, you know, well, but then we get the data and it's 8 months old and it's stale. And, you know, and why should this important data only go to certain people who FOIA? Should we all have them? And I know AIIA holds that view. We should all have this data and we shouldn't have to sue to get it. So I, you know, just to kind of shed some light on that part of the industry advocacy and Section 107 that Bill alluded to earlier, it is the service's position that they are hamstrung, that their hands are tied. They cannot have the kind of conversations and dialogue and information sharing with us because the statute prohibits it. I will just say that I profoundly disagree as a matter of law, and we have taken every opportunity to brief the legal analysis on Section 107 and other barriers that have been brought to our attention as to why the service cannot engage with groups like IIUSA, AILA, AIIA, EB-5IC, others in the industry on these kinds of really high-level important issues. Those arguments just really respectfully carry no water.
But that's not all the time. Like in the last engagement, Julia Harrison did respond to Gary Mercer when he said, can you share this data more regularly, the inventory data? And she said IPO was struggling with how to report this data in a useful way. So the point is, I think there is a little bit of initiative from their side, which is, hey, this information is important, let's get it out there. They're just not sure how to do it. I think if there was a way to engage with them, and seems like we're all doing it through the ombudsman, is that maybe we should prompt them and say, look, it's fine, just give us what you have, we'll do the rest of the work. We know your job isn't easy, we get it, you're dealing with so many petitions, all coming in through the mail, you got to hand count it, all of that stuff.
Yeah, but practically, how would that go? Like, just give it to us, give it to whom?
Just publish it online. I mean, I talked to Charlie Oppenheim and he said he used to get a monthly report every month.
That's to a fellow government agency, like that's to the visa office.
Correct. So
I
if
mean,
you
I
can do
just,
it to somebody who works with you, why can't you do it to the public too? Especially if it's we are your consumer, right? I mean, we pay the bills that pay their salaries. So isn't it like worthwhile to the consumer that's consuming your product that you be fair with them and you tell them how many seats there are on the train before you let them on, before you sell the ticket?
yeah, no, I mean, I want that information, believe me. I'm just wondering, if that's the issue, if the data is like too raw, I can see the discomfort in releasing it publicly. Um,
I'm sorry, could you explain that?
No.
Where is your discomfort coming from?
Well, I'm just thinking well, that's why I asked you what the data looks like in its raw form. I mean, is it just like Excel spreadsheets? I can see, I mean, I wouldn't want to release Excel spreadsheets, or is it more, or does it look more sort of coherent, like countries of nationality, 526E petitions, TEA categories? I mean, that looks a little more coherent. And so maybe one would be less worried about misinterpretation so that's where my question was coming from. Like,
I
what
mean,
does that raw
I-
data look like?
Ishaan, did you publish the data that you received in the FOIA so that we could take a look at it and see what is coming?
Here, I'll just show it to everyone if you guys really want to see it. I've removed the data because again, I would prefer it if people would actually donate to us because we did have to pay for this lawsuit and the future lawsuits we'll engage in. But this is what the raw data looks like. This is what the template looks like. You've got, the total I-526E receipts. Then you've got your rural only petitions for all other countries, China, India, South Korea. That's what we asked for, was these countries, which we believe is the highest. Then we've got it for rural only. And then alongside that, then you've got on the right, you've got all these mistakes, essentially, people who did not check a category. Over here, then you've got people who check both rural and high unemployment. So I'm sure there'll in fact be more of these. Yeah, we'll actually get infrastructure, we'll get all of that. And yeah, I mean, it's terrible. To me, the biggest disservice is I've only got it from April to April.
How much do you want us to donate so we can get a copy of the data?
I mean,
This is
if it's
really
right on their
important.
website, you
Bill, I
can.
know your assets under management are big enough. So how about
What's
5,000?
that, please?
I
What's
think
that?
I think your assets under management are big enough. So I think a $5,000 donation to us.
It's
It's same that other regional centers have also done as well.
Ishaan, did you provide that template, with those categories, or did it come like that? I mean,
we made a FOIA request and we sort of asked for like this is the kind of data we're looking for. We did send a spreadsheet. We did not get this spreadsheet back. They modified ours and sort of put it in.
Oh, that's interesting.
But yeah, that's. But again, they have the freedom to do that. Again, it sort of depends on how you word your FOIA request and also the argument you make when you actually put your FOIA suit forward. I think our, counselor did an excellent job of forming a really well-written complaint, and I think it made a lot of sense. So from the DOJ, when we, were negotiating with them and everything, I think it was just a matter of, hey, we've got someone working on it. They're going to put that Excel sheet together, and I got a stupid CD-ROM, and I just read off that.
Did they give you the raw data as well, or was it just? And I'm really just curious.
Yeah, the format is fascinating.
As well as the spreadsheet, or no?
That's what it came in. It was the spreadsheet burnt onto a CD-ROM, which I had to read off of, and then copy it. And
but that was all. They didn't give you the backup of like, I don't know what else they would have, but they didn't. But all you got was the spreadsheet, basically.
Essentially, that's all we asked for. Yeah, we could have asked for other things like approval data and all of that, but we filed this request in May, and honestly, nothing had been approved at that point.
Right. Great.
So what are we feeling? I'm genuinely curious. What is our feeling about the numbers situation? It's a very open-ended question. I'm interested in if folks have like a prediction about when we're going to start to see backlogs in the set-asides, and even, we're going to start to see set-aside backlogs in this category for folks from this country first. To what we really need are more numbers, that kind of feeling, or, market reactions. Is RIA, roaring back in these markets that were just dark for 9 months? It's just, what are we thinking about the numbers situation right now? Ishaan, I'm going to start with you because I'm curious. You're very plugged into the investor community. So, I mean, are people feeling like, oh, we can breathe again, we can invest again, everything's opened up, priority dates are moving? What's the feel?
I think it's just a matter of those two big countries where there is the possibility of retrogression, China and India. Because the reality is that even if, say, other countries, say like one of the countries we saw where we're seeing a very high volume is Taiwan, even if it crosses that 7% threshold under its category, it overall doesn't use as many EB, visas to begin with. So I wouldn't really worry about something like that. I would worry about India and China for sure, but also then you got to keep in mind is that what if they use up all the visas? What if rest of world also has a priority date assigned to it, which is a very real thing. Just based on the existing data we have, we could just sort of, if we just take some rough math, which is multiply each petition with say 3 dependents and assume everybody gets 100% approved, everyone is approved. So now we can kind of tell that, wait, the number of visas needed is lower than the supply. So there's a lot of questions that come into play. So then efficiency is a big question. Are all these petitions going to be approved? And then more importantly is like if and when these petitions are approved, are they all going to be used within this fiscal year? Because remember, this particular fiscal year that we're in is really special one. We've got a huge number of visas available. That's why this visa burdens jumped now recently as well. So what do you do in a situation like that? I think it is imperative for us to encourage the agency to adjudicate as many petitions as possible and move them to the next stage. And that is important because many times petitions get approved, but they don't get transferred. The file doesn't get transferred from IPO to NVC efficiently. It's one email that takes, months to send. So if you're dealing with a situation like that, if we can help sort of make that faster, then there should not be too much of a fear of a backlog. If things remain the way they are, if the adjudication remains slow, if visas are assigned in a very, very slow manner, then yes, I could easily see investors stop investing from certain countries because now they will know that there is a backlog. It's not going away. It will take at least 2 to 3 or 4 fiscal years until my country of birth in that particular set-aside category is current. So that is something to be aware about. I think that is why also we're seeing a reduction in the number of people investing from China in the high unemployment category. And I think it's only going to ramp up as we get, newer and newer data.
Yeah. Well, okay. But then we also have concurrent adjustment. What are we feeling?
So, all right. So I'm okay. Come on. But that's like for investors who are living in the US. You've got thousands of your clients, your investors who are living outside. People forget all about them. These people invest their hard-earned money. They wait nearly a year, 3-4 years just to move to this country to call home. And, that's okay. It's not. That's the whole issue. Thank God the sustainment rules have changed to now what they are. Because if it was different and there was invisible backlog, now you're talking about them getting their money back years from now.
Let's talk about the sustainment or it's whatever we want to call it, the web announcement or the email announcement. So Bill, what do we got here? Or should I set the table?
You can set the table. We only have 10 minutes. So
I know. And then people, I do.
Okay. I'm going to eat dinner real fast before you set the table.
Have dessert first, as I like to do.
Yeah,
So there's this announcement by email from USCIS, and the interpretation of the RIA is that the sustainment period is 2 years from investment, and so the front end and not the back end, as it is in footnote 4, as it currently still is in footnote 4 in the policy manual. So let's set aside what do we do with that inconsistency, but just at a bigger, a higher level. What is this? How do we make sense of it? Is this good? Is it not good? Help us digest this.
Is the 2-year sustainment policy good?
Let's start with that.
Here's where my head is this, and I'll just be quick because I know you've got 3 people in.
And I know Ishaan has,
The issue with this
maybe
is, look,
Morris too.
I think everyone would agree. The current quagmire of people's investment remaining for 15 years or pick a number and it redeployed and whatnot, it doesn't make sense, right? But it is what it is. It is the law. There's a regulation out there, et cetera, that says this is what's supposed to happen. CIS then decides on the average Thursday that they're going to come out and say it's a 2 years, which makes no sense. They got to follow the APA. You cannot violate the law and you can't just publish this thing and assume it is now the law. The problem that I have with it is I have a lot of problems with it. One of the problems I have is Sally and Joe invest, and they are investors, and they are in a 2-year deal with a 956F that says it's a 2 years. And then in a year and a half or two, whatever it is, that gets overturned. The 956F is denied. The 526s are denied. Thank you very much. Have a nice day. You no longer comply with the sustainment rule, which is the current one. And so we do need to change the sustainment rule, whatever you're going to call it, but you don't do it by a posting on a website. It's not fair to anybody. Investors are going to come in with a false expectation that they can do this for 2 years. It isn't real. And even if you read the sustainment policy and you follow, it's still going to be, I mean, Glasgow, I think, said it was 4 years, that kind of thing. So I have a serious problem with publishing something this substantive on a website, which I believe is in direct conflict with the regulation. With that said, very legitimate people in this industry are going to go forward and they're going to say, I don't know, but I think it's a 2-year policy. Let's go ahead. The confusion from an investor's perspective and from a regional center and an NCE operator or whatever it is real. And I think that for CIS to do that was a big mistake. They should have followed the EPA, and that would have clarity. So anyway, and then I have a lot of other issues. The current rules are nuts. I mean, people shouldn't be invested for this long. But to do this by posting on a website, that's not the way to do it.
All right, Ishaan, go.
No, I'll let David go first.
All right. Morris.
Yeah, so we discussed this a lot inside of AILA EB-5 committee. And I'm not taking a position either way that what the 2-year sustainment period should be. But it seems to me from a very practical perspective that just having it out for 2 years, from the date the funds are released, from the investor to the NCE and the NCE that starts the clock to the JCE, it just begets lots of big questions like how can those funds be deployed into a job creating entity that's going to build something of any significance inside of 2 years, stabilized and refinanced out. It's just not going to happen. So now you're going to have issuers saying we'll comply with the 2-year rule. We're going to get you money back as fast as we can inside 2 years plus 1 day. Now everything's going to be about bridge financing projects. And was it contemplated? It's just a mess. And it's very, very conceivable that an investor can release her capital to the JCE, complete her 2 years of sustainment period before she even gets an approval of the 526, before she gets approval of her immigrant visa, before she starts her 2-year conditional residence. So, okay, I guess if we follow this strictly according to an email notice with no more attachment to it, then this person could get their money back before she even starts her 2-year conditional residence. So then why do we even bother filing the I-829 petition, right? It's just a dumb policy. Dumb.
All right, it's dumb. Gotcha.
Yeah.
Ishaan, is it dumb? Is it dumb?
Okay, so obviously I have my feelings and thoughts about it, but just talking about from a practical point of view, I'm not an attorney. I can't really comment on the law. If they did follow the APA or not, that's really up to the courts to decide. I think there is a checklist that agencies have to follow when following that, when going to the comment period and all that stuff. There's also the Chevron precedent, which you guys can look at and see if it meets the step 1, step 2 criteria and how the interpretation works on that. But with regards to on the actual offering side of things, I will say that from what I've seen, typically most private equity offerings in this country tend to be around 3 to 4 years to begin with, in terms of investments that are offered in the public market. Then
are you just making that up?
No, I'm saying that as a fact. I've been to real estate conferences. I've talked to folks. It's not even forget real estate for a second. Put that sector aside. There are plenty of offerings out there that genuine private equity offerings that exist usually around 3 to 4, maybe 5 years, and they do exist. And you can look it up and fact check me on it. Then on the other side, but let's go back to EB-5, right? Like EB-5 offerings over here. The market has already adjusted. There are offerings out there that are offering a earlier repayment period. There are issuers that are negotiating with their developers or going back to the table and saying, is there a way that we can get the investors out earlier rather than making them wait 6, 7 years? there are offerings that like that exist now. And now I do believe strongly, now you can make the argument that, well, these short-term projects could be very risky and all of that. My response to would be is look at the free market. If let the investors choose. If they want to go for a super risky bridge financing deal and get their money out in 2 years, hey, that's the investor's choice. I do agree with you. It makes the I-829 moot. Maybe we should merge the I-526 and I-829 into one file and send that out there. I love that idea. But at the end of the day, like, I think investors getting their access to their money back faster is always a good thing. I think the fact that if an investor can do that immigration process independent of what happens with their investment and independent of that, and as long as those two things work in their own fashion, that's totally fine. If it takes 4, 5, 6 years for the agency to adjudicate my 526 or 526E, it would be great if I could still get my money back, if I invested my money, if I upheld my contract to this country, if my money created the jobs, I should be allowed to take it back once I can.
So, hey, Carolyn, I just want to say something quick. When my comments were mine only, and although I'm president of USA,
absolutely.
they're not USA.
Yes.
I don't think IIUSA has a position.
Totally. And allow me to say that the views expressed by our panelists are their own and do not represent their organizations. All right, wonderful. Heard you all loud and clear. I will open the floor for questions. We don't currently have any queued up, but I did see some hands before. So if there are any questions about sustainment, redeployment, or the numbers, hello. I'm gonna allow Lulu to talk. Who doesn't want to hear from Lulu?
Everybody.
Go for it.
So I actually wanted to go back to something at the beginning, which is about the winding down regional center, trying to do it gracefully and without necessarily, I mean, I don't even like the idea that they have to be terminated at all. It just feels bad that they can't just like withdraw or, go inactive. Like if you're not practicing law anymore, you don't have to get disbarred. You actually get to say I'm inactive, which is after, having a regional center for 20 years, it would be nice if there was a way to exit without being terminated. I just think that's horrible all by itself.
Yeah, but, Lulu, we when we sent a letter to USCIS and said the need to create a third category, and so it would say on their website it would say approve regional centers, deny regional centers, and the third one of retired regional centers.
Right, I agree. So I just wanted to say that when we had our quarterly settlement meeting with USCIS, I felt that it did shed some light on this issue of whether investors would need to reaffiliate. And it wasn't handled as clearly in the general call, but their in-house counsel said their position is to put the investor through the least trouble and turmoil as possible in the event that a regional center is terminated. And I think it was whether it's administrative or not, if they are meeting the eligibility requirements of job creation, money went in, all that stuff, that they would not likely
be forced to affiliate. I think that's a great interpretation. I really, really do. And I feel like that having made that distinction between administrative non-compliance termination and the bad terminations is very handy. Run with that. And if you're administratively terminated because you don't pay the integrity fee and you don't file the G because you want to gracefully wind down, let them, and don't make their NCEs reaffiliate. I think that makes a lot of sense. But we don't have that. And I think that our regional centers are going to feel very uncomfortable. I mean, some may not, some may be like, bring it on. But I think a lot of regional centers are not going to feel comfortable going that approach without something harder that they can rely on.
Yes, I agree. And they should just have a form. A regional center files a form that they are, retiring or whatever. Not that it's not complicated.
It's very interesting because it's like before this became a possibility, I don't think regional centers would have thought that they would be able to, it was only when the decertification, the mass decertification happened, that I think some regional centers were like, oh, phew, good. I don't have to do anything. I just take care of my investors and I don't, I can be let out. And then, so once that was set up, then it's like, then it kind of, now it's like, why can't we just do that? Because we've sort of seen that alternate reality.
I could say there was a lot of regional center operators that was very happy when the RIA came out and the service interpreted that to mean that all regional centers are terminated and that all those previously sponsored investors get to move on without a regional center. Their cases will be adjudicated standard. Like, we're like, everyone's like, oh, hooray, there's the exit. That's how it works. And if you want to move forward with the RIA, then you go ahead, right? And obviously they got reversed, but it was like the first time ever that the service actually addressed this issue of how to wind down, notwithstanding lots of requests, notwithstanding Vermont AAO and everything else. It was like the very first time. And so why they don't just go back to that and clarify it, make everyone's life easier? And wouldn't it make them happy to get rid of regional centers that, get them out of the program and kind of shrink the ranks? Like, that's kind of their underlying goal, I think.
Yeah, and without having to like administer reaffiliations and testing that and all of that. So anyway, we can hope we can continue the advocacy. Well, folks, we are, and bye, Lulu. Talk to you soon. My co-chair of IA USA's Public Policy Committee. Yeah. So we're at the top of the hour, so respectful of everybody's time, I'm gonna let y'all go. Thank you so much. You're like among my favorite people, like not just EB-5, like broadly. And so I'm just thank you. Thank you so much for joining me and for enlightening us all. Love you.
Thank you, Carolyn. Great job.
Happy holidays.
Fun to be with
Happy
you guys.
holidays.
All right.
Bye-bye.
Bye.
Bye, everybody.
Thanks, guys.
Bye, everyone. See you next time.